Hi, welcome to Patent Damages, what is really at stake. We wanted to start by thanking Jean, Renee, Eileen, Morgan, and everybody else here at IPWatchdog. Thank you so much for having us. We're going to go around the horn and each introduce ourselves so that you know a little bit about our background and about what brought us into the IP space. So my name is Erin Crockett. I am a principal with Charles River Associates. I have a PhD in economics. I've been doing litigation consulting for 20 years and IP specifically for the last 15 years. I spent 10 years as a full-time professor and part-time litigation consultant, so I didn't have a lot of free time. But now I'm doing this full-time, and next up we've got Janine.
Hi, I'm Janine Carlin. I'm at Aaron Fox Schiff. I'm the co-leader of the IP practice group at the firm, and I've been doing patent litigation now since the late 90s. Before that, I was working as a chemical engineer in pharma. And I'm excited to talk about damages because I think most people don't get excited about it. So I want to get you guys on board with this as an awesome topic.
Hi, everybody. I am Bette Muirhead. I'm a partner at Merchant & Gould in their Minneapolis office. I do IP litigation, all of it. So we're talking patents today, but I do trademarks, trade secrets, copyrights, and the occasional adjacent contract work, which is always fun. I, too, came up through sort of med-related in that I came out of a career in med device prior to going to law school. So that's interesting connection.
I am Nikki Glauser. I'm a partner with Kramer Alberti. I'm in our Austin office, and mine was much more by accident. I started off doing commercial litigation with Vincent and Elkins. My main mentor was the head of our IP section and would bring over litigators who he thought would be a good connection between our very brilliant engineers or chemists, biochemists, and the jury. And somewhere 3 or 4 years into my career kind of looked up and realized that my entire docket was patent litigation and that I loved it. Moved to a small boutique representing plaintiff sides, so patent holders, universities, small companies, and I'm now, I would say Kramer Alberti is maybe mid-sized boutique. So I'm exclusively litigation and exclusively patents.
Hi, I'm Ngọc Ngô. I'm an economist at Competition Dynamics. So we're an economic consulting firm, which means we provide expert testimony in support of litigation. So I have been learning and doing economics since high school. When I didn't know what to do with my life, but I know that I wanted to do something about economics. So it had been almost 20 years until 2 or 3 years into my PhD that I wanted to do to get a career in economic consulting, and not only only after a month or two after I started working that I knew that, okay, so now I do an IP. So it wasn't really original plan. I didn't really know what IP was. So I guess similar to a lot of us here, that I think IP chose me, and I guess I'm glad that it did. It's been 6 years since I've been doing it, and I think I will still doing it. I learn everything every day, so for the foreseeable future, I think I will still doing IP. So.
Thanks, everyone, for your lovely introductions. So we're going to start with an overview of reasonable royalty damages because most patentees, when they're in a litigation, what they're looking for is reasonable royalty. And then we'll also look at lost profits, which is a remedy that is sometimes available, and we'll talk about when that is the case. So to start, I'm going to talk a lot, and then I'm going to shut up. So just like if you're like, why is this chick still talking? Just FYI, that's how we set it up. So in terms of reasonable royalty calculations, a lot of economic experts like Nak and I, we will start with the valuation approaches of the market approach, the cost approach, and the income approach. Not all experts kind of, use that paradigm, but some of us do. I'm one of them. Market approach is really looking for, are there comparable licenses? So are there licenses to the patented technology or to comparable technology that you can look at and say, okay, this is the price at which parties have come to agreements previously. We'll talk a little bit about that. The income approach is looking at, are there incremental benefits associated with the patent at issue? Is there incremental increases in price? Is there incremental increases in quantities sold? Or incremental decreases in costs associated with using the patented technology? And then the related approach would be the cost approach. And the cost approach is there a way to design around or to design out the patent? And what would that cost? So oftentimes we talk about non-infringing alternatives, right? And so what is the cost of a non-infringing alternative? So those are the main three approaches. Nak, did you want to jump in and kind of add something there? Or?
I think you give a very good summary, and I agree that not everyone maybe call them or approach, say, market approach, income approach, or cost approach, but I think it's maybe different names, but similar thing. For example, market approach is talking about established loyalty and compatible licenses. Income approach is kind of an analytical approach, which talk about looking at the contribution or the value added of the patented feature to the patented products or the accused products.
Yep. A rose by another name would be as sweet, right? As they say. So in terms of, we'll talk a little bit about these different approaches through the context of the Georgia-Pacific factors, which, you know, if you work in damages, you're obsessed with GP factors. I've got them tattooed across my back, actually. No, I'm just kidding, across my arms so I can see them. And so, you know, so really these three approaches fit in nicely with the Georgia-Pacific factors. But one thing to note, if you're thinking about using the cost approach, there's been some changes in different venues, and it's not everywhere, but you want to be cautious of whether or not you have disclosed the NIAs that you're thinking about using, right? So increasingly, we're making sure that that the litigators we're working with are disclosing the NIAs in their interrogatory responses as early as possible, both what the NIA is and what it covers and why it's not infringing.
Hey,
Go
Erin,
ahead, Bet. Yep.
What's an NIA?
A non-infringing alternative. So that would be, you know, something that you could do instead of using the patented feature, right, which is commercially acceptable to the user, right? So it's really important that it's technically acceptable, that it's, you know, that it's economically acceptable. And so you want to disclose that as early as you can in your ROGs. And then also you may want to include it in an opening report by the technical expert. And in an opening report, potentially even by your economic expert. And so checking in with your specific venue whether or not that's appropriate. I don't know if you guys have been running into that recently.
Yeah. Well, it's appropriate in the places that we roll. But
Yeah.
I just want to back up for a second.
Please.
Because it occurred to me in working on a damages case last month that some people are a little confused about what happens with damages. So I'm going to take it super high level for a moment. It's not like the damages in trademark cases. It is not that whatever the infringer did and what they sold, you can't get their money. Okay, there's no disgorgement. It's not that kind of application here. And that is one of the reasons why this reasonable royalty and lost profits thing can get so weird and so science-y and very hypothetical. Both of them are hypothetical. And so you're dealing with getting to a number with all these pretend scenarios. So in a patent case, the least you will get is a reasonable royalty. So that's the floor. And that's what we're going to talk about with Georgia Pacific, which is the case name from the 70s that everybody knows and calls GP because it's so familiar. But that one is dealing with a hypothetical negotiation between the parties. So that is something which is why you have to have economists and your technical people and everybody involved in this to set up the hypothetical scenario. And then when we talk about lost profits, it's another pretend world that's called but for, which is another thing explaining to a jury, okay, we're going to the but-for world now, and then we have our inside jokes about, well, that would only happen in the but-for world.
Well, and if it's the other side, it's called the but-for world.
Yeah.
So if
but-for.
it's the other side, you put quotes around it.
Yeah, exactly. So that takes us up to high level there. And so I think what we're going to do first is talk about the GP factors, because those are normally where we land. Lost profits takes a little bit more complicated scenario to actually prove it. And it certainly can't be in a lost profits world if the plaintiff isn't selling anything. So they have to be on the market selling in order to do the lost profits analysis. And usually if you can get that, you're going to try both that and reasonable royalty. But reasonable royalty is something we all have to do. And the other thing I wanted to bring up here with comparable licenses is, before I make myself shut up.
Oh, no, please.
But the other thing I want to talk about here is a reason that I started working on damages was when I got to Arent Fox in 2003, I was put on a case and I was in charge of all the damages side. And I'm like, God, I don't know anything about damages. Listen, I'm a technical person. I'm a patent lawyer. I don't know any of this. That case wound up going for another 8 years after I started, and it went back and forth to the Federal Circuit many, many times, and is one of the most cited damages cases now. Everybody who has a damages brief to write will cite RescueNet versus Lanza. And
This is where everybody should say,
ooh, I know that case. I know that case. And I remember that I was working on this like nobody knew. I was the only one working on the damages part. I'm like, what's the case law on this? Can I use this? Can this damages guy actually use this license that doesn't say anything about the patent number? That doesn't seem right. Turns out it wasn't. And that's what's in the case law now. And so that decision came out in 2010 that is cited the most. But it was a great learning experience. And one of the things I realized, and this is my message to you, if you're a patent lawyer, is don't turn down those damages assignments. It's actually kind of fun. And you'll get to work with amazing scientists like these two here on some very complicated things, and it's challenging and it's fun. So that's my plug for people to do that.
And I'll second it, because I think it's the place where the whole story finally comes together, right? On the technical side, you have the very basics of, does this infringe, the claims and the limitations, and it's very deep and in the weeds. And then you have the inventor's story of, why did they come up with this? What benefit are they bringing to the market? How is this innovative? And on the damages side, you suddenly have all of that coming together to say, okay, what is the real world benefit here? We've talked about this from a technology standpoint, but part of the reason that we want to innovate is to bring real benefit to the market, to people, to consumers, whatever it is. And so the damages place is where that full story comes in. Your damage report, unlike your technical report, although we'll get into why you should also have the benefits there, really is almost like where you could craft the outline for your opening, for your trial. It is the, why are we here? Why does this matter? And ultimately, at the end of the day, what is the patentee asking for? And so it ends up being really fun, because it's kind of the confluence of everything about the case.
and I don't want to beat a dead horse, but I do want to jump on this bandwagon, if for no other reason to acknowledge something that I know I heard early in my career, and so it's possible some of you have also heard early in your career, which is that damages are often given to the young female associate because they're seen as easy or they don't matter, and it's the young male associate that gets the technical, the sexy technical expert stuff as their first expert witness. That's maybe true, but I will say for all the reasons that both Nikki and Janine have discussed, damages are very sexy as well, so don't believe the hype. If you've heard that, they do matter. The damages should be in your opening. Damages should be possibly the first line of your opening if you are the plaintiff. It is the why are we here. And so, and I have seen the mid-level associate who got as her first expert, the damages expert, turn that into a partnership where she can be called in on any case that is a little underwater to handle the damages. And I've seen her get called in where there wasn't a person to take damages, and she regularly gets called in to be that person because she's so good at damages. She's good at a lot of other stuff too, but when in doubt, you can call her in to do that. So you may hear, don't get stuck there, and absolutely get your technical experience too, but don't be worried if you get given damages early in your career or maybe even as your first expert. Because they're awesome. They write their own reports, which is amazing.
We really do.
And it is a crucial part of the case. So you're not being sidelined. And
I would
you
also
can make it.
plug that to say make sure that damages isn't getting second fiddle in the case to begin with. I think a lot of law firms can be misled to believe that our focus is going to be with the technical expert. Once we have that nailed down, we'll suddenly switch over to this very quick math formula of figuring out what our damage ask is. And the best damages cases, or reports, I think you'll hear today, based on the case law, they start at the very beginning. Like when we bring in a case, that is the start of us analyzing damages in a super tight marriage with the technology. So it is not divorced, it is not second fiddle, and if you get the opportunity to work on it, it's fun.
And I like what you guys are talking about in terms of you want to bring in your economic experts early so that we can work with you and try to figure out how to craft discovery, right? What is it that we need? What kind of data do we need? What kind of documents do we need? So I think it's important that we get involved early, but we'll talk about that in a little bit. So Georgia Pacific has some. There's 15 factors that one should be, cognizant of, and a lot of experts will actually go through each of those 15 factors. Not everybody does, and sometimes they're combined in different ways because some of them are so similar. Two of the most important Georgia Pacific factors are factors 1 and 2 that involve licensing. And so looking at any licensing involving the patent in suit or licenses that the defendant has entered into for comparable technology. And so I'm just going to pass that to Janine because she works a lot with technical experts and kind of best practices. So how do you, establishing technical comparability? What are your thoughts?
Yeah, so for this one, it is important to make sure that your licenses are aligned with what the technology is in the case. And there are a lot of factors about this. So you need to look at, is it just the one patent in suit? That would be easy, but you don't find that many licenses that are exactly the one patent in suit. You might find a family of patents. And how does that relate to the technology? So we do have connections between the technical expert and the economist. And many times, not just in this area of licenses, but also in non-infringing alternatives that we talked about briefly before, we will have the economist take a look after the technical expert is done with his or her report. The economist will review that report and cite it in their report. And oftentimes there's a discussion by phone between them to really get a good understanding. And sometimes there's more than one discussion, right?
Yes, and we often talk to the technical team before we talk to the technical experts so that we're up to speed, so that we don't take too much of the technical expert's time, but yes.
Yes, and also discussions with the client. So that's really important too, and I think I do that for every one of these, where we talk to the client ahead of time and say, here's the kinds of questions that will be asked, can you be ready for that? And then connect the client and the economist together and really get the information they need to have that deep portion of their report that has a lot of bases. Because the reality is, the economist seems to be the one everyone goes after for a Daubert. right? So we have to look at this.
It's
and
not
go,
great, guys.
It's not.
It's really
No.
not great.
And we have to protect these guys. And we don't want them doubted in our case, and we don't want them excluded, you know, and then they've got a black mark on their CV, and they have to explain it in every single deposition.
And then we have to go back to teaching.
Yeah. So in that case, it's important, and it's on us as attorneys really to make sure that we build each one of these sections and make sure that the economists have access to the technical experts, the documents, and the client.
Yeah. And especially when you're talking to folks who are at the company, it's like sometimes you can learn things that none of us really. We just recently had a call with somebody on the technical team, or I shouldn't say technical team. It wasn't but in product development at the company that we were anyway, and they said, oh, there was this whole new product that came out that displaced that other product, and we were like, we had no idea about this, and that was really helpful, and it helped us kind of craft a story of limited incremental benefits to the patent in suit that none of us really thought about until the last minute. Nak, did you want to add here about economic comparability of licenses?
Yes, so back to the Georgia Pacific factor. So I think it's not a technical, it's not an economic technique, but more to me is more like a kind of a bridge between economists and the law, because I know that when you do reasonable royalty damages, you have to talk about Georgia Pacific factors. It's not. So what we usually do is we construct our damages theory, and Georgia Pacific factor is just to make sure that those important factors are considered. And so we would translate, and in the report, usually, like Erin said, we usually group them, and it's kind of like after we already present our damages, we just, okay, we considered those factors and present it that way. On the comparable licenses, I think like as Jenny say, it's usually very hard to find the perfect comparable. I mean, in an ideal scenario, obviously, if you can find the perfect comparable, you can just apply the rate. But I think yesterday at lunch we talked about even twins are different. So you will almost never be able to find a perfect comparable license. It's important to find a good comparable license, and a few factors that you should consider when you consider comparability of a license. Like, is it a running license or is it a lump sum license? What are the number of patents that are licensed? In the hypothetical negotiation, is apparently is obviously the accused patent here, but then in the comparable or the potential comparable licenses, it could include a lot more patents. And it's also important to consider the relative economic position between the licensing parties, because, for example, if the licensor and the licensees are competitors, then the fact that they license the technology, they would create more competition for themselves, would reduce their profit. So in theory, the parties that are competitors, the license, the royalty would be higher. So if in the hypothetical negotiation, the parties are not competitors, then that need to be adjusted. So there's a lot of factors that need to be considered, and we will almost never be able to find the most best perfect comparable licenses, but it's so important to be able to identify what are the differences, and is there a way to adjust those differences so that we be able to make use of that comparable licenses. And I think that is where a good economic would help.
I agree, Nak. In terms of like competitive considerations, this brings us to Georgia Pacific factor number 5, which directly deals with whether or not you've got competitors for the reasons that Nak was saying, right? That you would expect that the reasonable royalty between competitors, ceteris paribus, all else equal, would be higher than non-competitors. We'll come back to that whole idea of competition and being competitors when we talk about lost profits in a minute as well. Another issue for comparable economic comparability of licenses might be timing considerations, right? So over how long is the license? How many years does it have left? What's the market share, right? So how many units are generally being sold by the different parties? That could be another, as Knox said, adjustments that you can make to get a license to be a little bit more comparable or get it into the zone of comparability that you need. Zones. Anybody else want to jump in on this before we move on to everybody's favorite, apportionment?
Well, I guess just one thing in case it hasn't really sunk in, but what we're doing with these Georgia Pacific factors is we're looking at all of them and saying, does that push the rate a little higher? Does it take it down a little bit? And that's why the dueling economists are it's pretty funny, because you'll have some that are, okay, everybody agrees they're neutral, nothing happens, but then you'll have, they're competitors, but for our client it would go up for this reason, and the other one says it would go down for this reason, and it's the same factor. So, but that's the fight, and that's how it all goes, and then you just have to see hope the jury's paying attention and taking notes on all these factors instead of just like, I think it's this. But that's why we go through all the factors to sort of see whether it pushes up or down.
And as Janine had mentioned earlier, this is all in the context of a hypothetical negotiation, right? A negotiation that has never actually happened, but you can imagine it happening between the licensor and the licensee. And that hypothetical negotiation takes place on the eve of first infringement. So the timing of the hypothetical negotiation matters a lot, and who the parties are. Sometimes people get the parties wrong, and it's a big problem for them, right? Or the date of the hypothetical negotiation, if they get that wrong, you could have the entire analysis excluded just for that reason. So you want your economic experts to be really, careful. Okay, so GP factor 13 is apportionment, and this is always our favorite. So this is where we're trying to figure out, can we isolate the value of the incremental, can we isolate the value of the patented feature specifically as distinct from all other contributions, whether they be from marketing or from the company's branding, from other patents, other intellectual property assets, other reasons that an accused product is successful. And so this is really the hard part. And so one of the tools that I know Knox team has used, and I know that because we are opposing each other a lot. And so she has seen us do regression. We have seen her do regression. It's just a lot of fun. So Knox, if you want to talk a little bit about your use of regression for apportionment, I know that that's an important feature.
Yes, so regression analysis is, so in case...
Give them the math, Knock. Give them the math. Go deep.
No, in case someone's not familiar, but regression analysis basically is just a statistical analysis that economists use. It's like a lab to economists. So economics is a science too. So we do have experiments, we do testing, hypothesis, and econometric is our labs. And I forgot someone who said yesterday that one of the good things in going to the industry, when you go back to the office the next day and you don't find things exploding, the good thing about economic is you can run your analysis and you come back the next day. The worst thing is your code just didn't work and you had to rewrite it, but nothing's going to explode. And regression analysis is not really an approach, but to me it's more like a tool which can be used in for different purposes. For example, we used hedonic regression, which is basically a type of regressions that analyze what different factors of the products contribute to the price of that product. So you can see, like, say, this is very important for apportionment, and say you would like to analyze what is the value of that feature in a multi-feature product. So hedonic regression would help to apportion the value of that patented features and isolate that effect from, or that value from the whole value of the product that make up that features make up the product. And we are still at reasonable royalties, but I'm gonna go to skip a little, go to lost profit, because I just want to talk about the use of like regression analysis as well. So I like how we already, it's good because we already set up the stage. We talked about hypothetical. Hypothetical, we talk about but for, which is make economic difference, because we are the study of the thing that didn't happen yet, and that is very important. And I think that is also where it gets confusion. It's very different from accounting, where you study what happened, but economic study about what didn't happen, and that's important in this case because we want to see what happened in a hypothetical, what happened in a but-for world, and regression analysis can help to answer those questions. So, for example, to calculate lost profit, you need to ask what the profit that the patent holder would have had if the infringement did not happen. It did happen, but it did. What would happen if? What would the profits if it didn't happen? So regression analysis would help to test whether profits of the plaintiff decreased and what's the effect of that infringement. And if someone asks, why couldn't you just compare the plaintiff's profit before or after? So one simple example is, says plaintiff profit has, without infringement, it would have increased by 10%, but in reality, it still increased because of other factors by 5%. So if you just simply compare before and after, you might wrongly conclude that, oh, there's no effect because the plaintiff's profit still increased, but that is the wrong way to look at it. And economists can help actually look at what would have happened, and so that's regression analysis. I will not go too much detail into this, but there are also other advanced techniques exist, more on the structural modelings, and we used it occasionally when needed and when the data available. For example, in one case also related to lost profit, the plaintiff alleged that the defendant had caused their reduced their sales of product A. But then after the analysis, we estimate the substitution pattern. So the fact patterns is the plaintiffs have two products, product A, and then later they introduce product B to the market, and then the defendants introduce the accused product C. So we measure the substitution patterns among these three products and a few others competitive products in the market, and it shows that the plaintiff's product A and product B is more substitutable to each other than the product C, which actually reduced the lost profit by a lot. So we used that in the past.
Absolutely. And so, like, as Nok is talking about, in terms of those tools that we have as economists, like, in terms of substitutability or complementary goods, we can look at things like price elasticity of demand, right? We can construct a demand curve and kind of like assess from there. We can use regression analysis. Mentioned one kind of regression analysis would be hedonic regression, where you're assessing how different features impact price. You can have structural break analyses. Also, Nak was talking about like before and after analyses. So that might be a Chow test is one way to establish statistically significant discrete change at a point in time. So there's other tools too. You may consider hiring a survey expert, for example. Survey experts can be a great way to provide apportionment to your analysis. They sometimes can provide good analyses of willingness to pay or importance of different features. And so you would want to get a survey expert in early also, and have that survey expert coordinate as is appropriate with your economic expert, so that the economic expert is getting what they need to from the survey expert. Yep.
Yeah, so on a survey expert, more recently, we work on a case that we have the survey expert to conduct kind of a data, and then we combine user to actually perform the econometric analysis. I know there are times that we have to use survey expert. We did before. I always have a more answers with the survey because there's a lot of issues with survey. There's potential
good surveys
bias.
And there's bad surveys.
But good surveys and bad
there
surveys.
Can be
Yes.
very bad surveys.
Yes. So I think, but there are times that there's no data, there's nothing we can do about it. Then we need a surveys expert, and even though we are not survey expert, but it's good even as economists, we be able to communicate with the survey expert just like we communicate with the technical expert to explain what we need and to make sure that the outcome of the survey is less subject to biasness. And
well, sometimes, I mean, to that point, sometimes you can get it in the ordinary course, right? So sometimes through discovery, you'll get survey evidence that you can use that your, experts can rely upon, both in terms of like importance. I mean, because we work for a lot of tech companies, for example, and they do a lot of surveys. They do a lot of A/B experimental tests, you know what I mean? Like where they're like including a feature, removing a feature. And so that's the kind of stuff that you want to be cognizant of.
Sorry.
Yeah, please.
I was just going to say, I would be very curious. I know I've had a case where we had a survey expert. I think ultimately it didn't end up, unfortunately for us, making that big a difference. But I'd be curious, Janine and Nikki, if you guys have used survey experts in the patent context, because I do think it remains a little rare, and how that worked out for you.
We have, and it has worked out well. I think you have to pick the times when you do it. We don't do it as a matter of course in every patent case that we handle. It is oftentimes when there is other underlying data that is missing. And the reason, of course, for that is we keep talking about a hypothetical negotiation or these very abstract, even for me who deals with the economists all the time, of regression analysis and these other kind of abstract principles. But the Fed Circuit is tough on damage experts and really requires that whatever the opinion is ultimately be based on facts of that case, not general economic principles that would guide you if you were teaching a class about how, markets typically work, but instead very specific facts that tie these numbers, these apportionments to this particular case. And so in instances where maybe through discovery we have not been able to get those underlying facts that make us feel comfortable enough with what we'll want to be an apportionment theory, then we'll do a survey. And we've done, two different kinds. One is a conjoint survey that is this more, how much would you be willing to pay for a particular feature among a feature set? The other, I don't have a great name for, but I'm going to call it like a direct survey. You economists can tell me a better name for it if you have one, but effectively that's more For example, would you leave, let's take a recent case of like a carrier, right, a wireless carrier. If your wireless carrier no longer offered feature X as part of your subscription, would you leave? And you can then, from that, come up with basically a churn or an at-risk revenue or profit of, you might not be willing to pay more for this particular thing because every consumer expects to get this feature with their plan, but if you don't give me that thing in my plan, peace out, I'm going elsewhere. So those are the kind of the two places that we've used surveys, and not all the time.
And to add to the conjoy analysis, I think now they also have a kind of additional similar type, like choice-based conjoy analysis, which is when you, instead of asking the direct question of how much you would be willing to pay, they give you maybe a list of 5-6 products with 5 to 7 features, and ask you which product would you pick based on these features. And I think there's literature show that these type of surveys have their advantages in certain cases, and then there are times that we use those results as a database to conduct our econometric analysis, and to measure what consumer willingness to pay for certain features.
Yeah, the same way that you would want an economist who knows the literature and knows what the underlying assumptions of their econometric models are, you want a survey expert who understands, you know what I mean, at a deep level what the pros and cons are of all of those different survey methods. So we've been talking a little bit about lost profits. I just want to jump to specifically to that, because while the reasonable royalty, we're assessing Georgia-Pacific factors, in lost profits, we're assessing the Panduit factors. And so the first is demand for the patented product, which we can use all of those different tools that we've just been talking about with apportionment with respect to that. And then we've got absence of acceptable NIAs. Janine's going to talk about that in a second. Marketing and manufacturing capacity. So if you said, this competitor took these sales from me, well, could you have made those sales? Could you have made the product, and could you have sold the product? That's important. I'll tell you, I was on a case once, we really wanted to use lost profits, and we had some major issues with capacity and had to abandon it entirely and just go with a reasonable royalty. And then the last factor is really a throwaway. It's just quantification. It's not a real factor. So there's 3. Janine, please. Absence of acceptable NIAs, this seems to be where really the rubber hits the road.
Absolutely, and with the technical experts contributing significantly here, because basically, the plaintiff is going to try to say there are no alternatives that are acceptable, non-infringing, available out there on the market.
It's because it's true.
And the defendant will say, oh, look, you could use all of these. They're fine. So this is the big argument on that particular factor, and it's something you need to start developing at the very beginning, and that's why I think it's important to talk about here, because even if you think there's no way I'm ever going to do damages, you're going to be involved in this part, because there's discovery that needs to be had into what are the other products that are out there, how are they used, what are they like, what is their cost, if like some of our clients will have a lot of this data because they're looking at the market. And they will have things in there that maybe you may need to look at because they could be incriminating. Like all of these compete directly with us, and they're all, our customers switch from one to the other. So if you're plaintiff and you see that document, you need to be thinking about how you're going to deal with that. So it's a place where you need to have the discovery on your end, and you need to have your technical expert dealing with it in his or her report. And so they're going to explain, if you're plaintiff, all of the reasons why this is just not acceptable. And so, for consumer products, it could be it's not a comfortable thing to use. So therefore, it's not acceptable. Or I would only use it. I don't use it at night. I use it only during the day. And the other one you can use 24 hours. There could be lots of little arguments here that in the documents or the technical person can say that's why. And even in, for example, in pharmaceuticals, it could be, well, yes, a lot of people use that product, but it's not FDA approved, and really you want an FDA approved version, approved for this condition. So there are a lot of things that you can develop throughout the whole case to be used by the economist here. The economist is not going to know or have the information on her own. She's not going to be able to say, oh, these are acceptable, they're fine. No, it's got to be supplied by you in the case. So it's one of those very important pieces that you work on with your whole team.
So those are lost profits considerations and reasonable royalty. We're going to take a little bit of a deep dive into everybody's favorite eco-factor v. Google. We've all been talking about it constantly. Bet, please let us know, what is this important case and why do we care about it?
So I'm going to give the background just in case you heard eco-factor v. Google and went, huh? So this
How many
is a
people
case.
know this case? Okay,
Well, there
no,
we go.
Bet, you've
All
got,
right,
you've got
I've got a
good audience.
captive audience
Yeah.
here. This is amazing. So this is a case that came out in, I want to say May or June.
I think March.
March.
but
Okay.
I could be wrong.
Started with M. I was close. It came out this year, so it is still a fairly recent case. This is a case about reasonable royalty. It is just the tech, if anybody's interested. It's a smart thermostat patent that EcoFactor owned and asserted against Google's Nest thermostats that you can use in your smart homes. In this case, EcoFactor, well, one thing to note, Google didn't present a damages expert in this case, which I find fascinating. And so Google just relied on cross-examining EcoFactor's expert witness to try and negate his reasonable royalties analysis. And so EcoFactor's damages expert derived a reasonable royalty rate that everybody refers to as royalty rate X because it is still sealed. Nobody knows what it is outside of the case. And he did that by taking 3 litigation settlement agreements that had lump sum payments and dividing it by basically estimated unit sales for each of those asserted infringers and saying, this is the reasonable royalty that we would have gotten. There was also in those agreements some language in the whereas clauses that said, EcoFactor, in fact, believes that this is the reasonable royalty rate, but in at least 2 of those agreements, there was an express disclaimer saying, but the lump sum that we've come up with here doesn't reflect a reasonable royalty and shouldn't be considered a reasonable royalty rate. So Google, at the trial court level, moved to exclude under 702, saying that the analysis was unreliable because the expert presented X as the rate that others were willing to pay, despite the fact that 2 of those agreements expressly said that the people who were agreeing to pay a lump sum were not agreeing to pay a reasonable royalty rate of X. They were just trying to get rid of the case by paying a lump sum. And then they also argued a failure to apportion, which we've talked about. The settlement agreements in this case were sort of portfolio or family-wide settlements, so they didn't just cover the asserted patent. They covered a large number of patents owned by EcoFactor, and there was the EcoFactor expert basically said, well, there are factors that cancel it out. So yeah, I might have brought the rate down because it covered a patent portfolio, but I'm going to bring the rate right back up to X because of other factors that would have raised the royalty rate. And Google argued that that was not really actually apportioning for the value of the 327 patent, which was the patent that was at issue. The trial court denied the Daubert motion and allowed the testimony in. The jury found liability and awarded a little over $20 million, which when you did the math was basically granting that X royalty rate. And Google first moved for JMAL or a new trial on damages, and when the judge denied that motion, they appealed. The Federal Circuit, the panel that heard the case first, affirmed, basically giving deference to the gatekeeping discretion of the trial court and saying that this really went to the weight of the evidence. And so it was a factual matter that should have been in front of the jury and the subject of cross-examination. It wasn't about the reliability. It wasn't something that should have been the basis for a motion to exclude. So then Google moved for en banc review, and en banc review was granted. The Federal Circuit on en banc did limit it to just this question of the use of the 3 licenses to support an X reasonable royalty rate. They did not hear argument or have briefing on that apportionment question that had come up or other arguments that had been made in the Daubert. On en banc, the Federal Circuit, by a vote of 8-2, it's worth noting that Judge Newman was excluded from hearing the case and participating in the decision, and Judge Cunningham didn't participate. I'm not positive why. The Federal Circuit held by a vote of 8-2 that the expert testimony should have been excluded as unreliable. The way they did this was fascinating. They recharacterized the issue as being an issue of contract interpretation. So it was a question of law. It wasn't a question of fact. And then they interpreted the contracts based on those express statements that I mentioned as being expressly contradictory to the position that the expert had taken, that they were reflective or could be used to reflect a per unit royalty rate that others were willing to pay, because they expressly said, that's not what we're doing here. In light of that interpretation, the court found that there was insufficient evidence to support the expert's testimony and said there also wasn't enough evidence in the record because the only other testimony was self-serving testimony by the CEO of EcoFactor saying, yeah, this royalty rate was used, which on cross-examination he had to admit that he didn't actually know that that was true. His basis was just sort of general information from the industry, and he couldn't support that that royalty rate had been used because he had never actually seen any sales data from any of the opposing parties. So he couldn't say, yes, we used, and I'm just gonna stop saying X, yes, we used $5 per product, and they sold 1 million products, and so we got a $5 million lump sum. The court did say that this gatekeeping function under 702 is about ensuring that the expert isn't presenting a conclusion that no reasonable jury could reach based on the actual evidence. And so they were saying it was a little bit of a, was the evidence sufficient to support the jury finding? No, the expert shouldn't have been allowed to testify to it. And that's sort of my read on what they were saying. There were 2 dissents. I won't go into great detail, although I would be very interested to hear people's thoughts on the dissents. Judge Reyna, who had been on the original panel that decided the case, wrote one of the dissents. He was joined by Stark. He criticized the majority for using this contract interpretation theory in the first place because it wasn't briefed and it wasn't argued. And he said, well, that's fundamentally unfair to EcoFactor. And then he also said that even if this contract interpretation theory was correct, it was harmless error because he disagreed with the court that there was no other evidence in the record that the expert could have based that X royalty rate on. And so that was his argument. Stark also dissented, and he was joined by Reyna in his dissent. He wrote separately, mostly to voice his concern that he was worried that this case would be overinterpreted and overused. He saw the case as being a very narrow holding that should only be applied in extreme cases where there is actually no evidence that would support the expert opining the way that they did. And he, like Reyna, believed there was other evidence in the record that could have been used to support this rate, and so it should have just been a weight, not admissibility. And so he even said that he basically agreed in principle that a court shouldn't admit expert testimony that is unquestionably at odds with the evidence, which is what the majority said the gatekeeping function that it was opining on here was about. He just didn't agree that that's what the evidence showed here.
Thanks, Bet. That's very thorough and very helpful. I'm going to jump to Nikki and get your thoughts, because please, everybody's got thoughts on this one. So.
One thing that just jumped out at me, I don't know, Judge Stark, personally, this is entirely like Reg. I am not speaking for him, his clerks, his decision, but it can't be ignored that he recently came from a district court bench. And in this decision, Ecofactor, the en banc court really took the district court judge to task for not having, in his opinion, on the motion to strike or the Daubert motion, included even sufficient facts to sustain the opinion. So it was kind of two levels. It's one, the expert didn't have enough facts for their opinion to be admitted. And also, by the way, hey, courts, when you're ruling on these Daubert motions, we're warning you, your order needs to have sufficient reasoning and facts supporting why you are admitting it or excluding it. And I think probably as the most recent district court judge, he recognized how difficult that ask is going to be of courts. And so kind of making sure that this ruling was very narrow when it is black and white. When a license says it is not X, you can't then have an expert come in and say X is a bad example. It is not red, to have an expert then come in and say it is red. And in those instances, the court should act as the gatekeeper and keep it out. But if we're talking about variations of things or interpretation of things, to ask the district court to jump into that role is a big ask. And so part of what we've taken away from it as lawyers is we need to make sure that we are feeding to the court all of the facts and all of the support that would get a ruling in our favor, not just as the final order, but in addition to that, the memorandum opinion. Because otherwise, if I get my expert in through the district court order, but it's not sufficiently supported for the Fed Circuit, who obviously now is not having any problems overruling a Daubert gatekeeping function, it does me no good. I'm buying time for defendants to not want to come to the table, or for not discussing settlement, or for looking at a verdict as not any real risk. So that's part of our takeaway from it. I think the other thing on this is part of what we've been talking about of protecting your experts, right? Of making sure that your experts have all of the good facts and all of the bad facts. I don't know why, he's a fantastic expert. I don't know why he only in this report relied on these whereas clauses in the license. My guess has to be that he didn't have access to other information that would have belt and suspended, like fixed it almost. Because I think even with these whereas clauses, you could say that the accused infringer was saying in our mind, this doesn't represent a reasonable royalty rate. But I've done the mathematical calculations. I have the other facts from this case and from general economic principles that supports that it in fact is, and thus this license is further evidence of this rate rather than the only basis for the rate. And so this is just an additional plug for making sure your experts that you're working with, technical or economic, that you really are setting them up with all the facts. And I'm a big proponent of the bad facts too. I know sometimes we want to protect our experts and not let them know the bad facts because somehow then they have to consider it. In my mind, these people are so smart. These women are amazing. Give them the bad facts because they will craft a good story from the bad facts as long as they know them. When you're presented for the first time in a deposition or even worse at trial with a fact that your expert didn't know, that on the fly, number one, if you're in ED Techs where I practice a lot, if you didn't include it in your opinion, you're not saying it to the jury. So you're kind of stuck with mum's the word. I didn't address it. I can't address it now, really. And so I think that's kind of my takeaway in some parts. There's a few more, but I'm going to pass it on because this is too big for me to talk the whole time. But is really to make sure we are back to this. Opinions are based on facts in the case, a lot of them, and that your expert has those.
Thank you, Nikki, for that. Yes, we do want the good facts, we want the bad facts, and we've got to remember to put it in the report, 4 corners, right? Janine, what do you think about this one?
I think you guys explained it beautifully, but I have a couple of things I just want to add, and that I think Judge Stark is so right, that we are going to see this over and over again, and it's going to get a life of its own. It already is getting one. And I think it's going to be expanded beyond what it was meant to be. So I am worried about that aspect of it. And then the other part is, with respect to the agreement itself, it really has made me think about my own settlement agreements and how to draft them. So that goes to everybody, all of us who are not, in-house attorneys working on settlements that aren't doing damages. This is instructive because you want to make sure that the language in there is not going to be something that will hurt you later with respect to trying to use this agreement in a future litigation. So if you think that this settlement agreement is going to help you in a future litigation with someone else in a damages analysis, and you've got that language, hey, we think it's a royalty rate, but we don't, then it's not coming in. So that was another takeaway, is my own practice is that we need to carefully look at even the whereas clauses, which people skip over. And I guess my last thing on this was, in listening to you discuss, having all the facts in there, this is hard sometimes because we have limits. For example, your Daubert motion is X number of pages. And so you've got to put all this in there that you think is going to keep going. And you can try to do it with all your exhibits, but you have a limited amount of pages for this and for motions in limine. And then when you actually go to trial, we all have time trials now, which is crazy when you have 9 experts and 5 patents, and you have to, your damages person goes last. It's like, okay, Erin, you've got 1 hour to present 15 Georgia-Pacific factors and 4 Panduit factors and make it easy for the jury. And have all the facts in there that there's testimony, and you can use this in your post-trial motions. So all of that is another thing that, while you were talking, I'm like, this is just, it's difficult. So we have to be on it.
Yeah.
I just want to add, so I'm going to try and say this clearly, but this is also a little bit of a plug for not putting all of your eggs in one basket, too. I also don't know, I'm not as familiar with this expert, but I mean, one of the things that both Judge Reyna and Judge Stark said in their dissents is this settlement agreement was, if nothing else, evidence of what Ecofactor believed was a reasonable royalty. They stated it expressly. And then even though the other side basically didn't agree, it strikes me that the sort of taking the strong position of I can just do this math based on estimates and back calculate to get to that reasonable royalty rate was a bit of a miscalculation when there could have been, and maybe it was a lack of data, I don't know, but he could have put more weight possibly on that idea, and I think people are speculating that on remand this is exactly what he'll do, but he'll say, well, these are evidence of a reasonable royalty rate because they're evidence of what Ecofactor would have licensed its products out for. They said what they believed the reasonable royalty that they were giving via this lump sum is right there in the whereas clause, regardless of what the other side made us then put into the contract as far as the disclaimer goes. It is evidence of Ecolab's willingness, and as noted, Google doesn't have anybody to rebut that. They don't have a damages expert. They're just going to go up on cross-examination. And so it is a little bit of maybe a covering all the bases. I believe that this is both what eco-factor would expect and what others would be willing to pay, but I'm not basing my opinion on either of those things uniformly. I'm also basing it on this, and this, so.
What's interesting, we also don't know what was in the report. So we
Yeah.
often have expert reports that
That's
have
true.
two entirely,
Yep.
I mean, they're complementary, but they are two entirely different damage theories. And the fact that they may come out somewhere close is indicative of the fact that, like, maybe that is the right number. But when we go to trial and Judge Gilstrap tells me that I have 10 hours to try a 3-patent case, we're not presenting both damage theories usually. We're picking one. And so I don't know from the facts of this case, I actually haven't read the Daubert motion, and so much of it would have probably been redacted anyway, but I don't know if there weren't other theories in there. And then once this one got past Daubert,
That's what they relied on.
the trial attorneys very rightly said, this is the easier one to explain to the jury. This is the horse that we're gonna ride. Let's go for it. It hasn't ever happened before that the Fed Circuit has stepped in this way. Some of the judges that ruled to affirm the district court decision on the panel decision flipped on the en banc decision. So it's kind of very unique circumstances, and I think it's part of why all of our ears are perked and why you're starting to see it in other decisions. There's a more recent Fed Circuit decision in which the court overruled an invalidity finding, and the damage number wasn't per patent, it was total damages, which meant there had to be a new trial on damages because one of the patents was invalid. But the Fed Circuit didn't stop there. They warned the expert and the district court on remand, when you're looking at damages for the remaining valid patents, don't forget what we told you in eco-factor, because what you said at trial the first time might not pass muster. Hint, hint, go back and fix it. So you're seeing pretty expansive application of a broader, more aggressive ask of the district court in applying 702.
Yeah, so I believe that another fact is equal factors damages expert didn't just assume that red rate or X rate. Instead, he endorsed it based on his experience as a licensing. So that is also something I feel like play against equal factors. And I also feel like this is sounds to be a narrow decision, but since there's a general pessimism that district court may apply the decision broadly, and that will lead to a higher standard for Dauberting damages expert. Now, to be fair, I'm not against high standards because I think high standards make great system, but I think that the standards need to be defined correctly and applied appropriately and fairly. I also had a feeling, like I think Jenny mentioned, that damages expert treated harsher than all the technical expert, and I don't know why, but one hypothesis is like economics is a science but easier to understand for most people than maybe other technical sciences. And but the most often the people oversimplifying the matters. So on the surface, economics or may sound simple because you can understand it, but under the surface, when you look closely into it and do it the right way, it's not that simple. So I am, like yesterday, I think the acting director gave an example of the post-it. This may not be the same, but I want to use it as an example. Is people say post-its, they doubt it. This obvious because, hey, it's just sticky, like we had glue before. It's just paper, but so it's simple, right? But it's not that simple. So I think the problem is simplifying is good to make people understand, but oversimplifying and incorrectly evaluate or judge the damages expert is a little unfair to us, I think. And I also want to say thank you on the bad facts, because as someone who experienced myself, I'm not afraid on the economics, when I'm never afraid of reading the criticism of the opposing expert. What I'm afraid the most is when I read the rebuttal report, or when the deposition, people bring in the facts that I didn't know before. Like, oh my God.
Not
So,
good.
not good.
I think one thing that I'm wondering about with EcoFactor, and it is true that, you know, it may end up being a very limited and narrow scope, and it may not have much of an impact at all. But to the extent that it has an impact, I'm wondering whether we'll see more use of the income approach and the cost approach by economic experts, potentially through the use of regression analysis and other, as opposed if the bar of licensing gets too high. And I'm not saying that that's a good thing. You know what I mean? It's just a thing that, and having all of those different tools at your disposal, and then using as many of them as possible, like you said, Nikki, in order to kind of show consensus is great. And then at trial, showing all of those different, bars in a bar chart. We all love bar charts.
It goes back to high school math of show your work.
Show your work, exactly. Well, I think we've run out of time. So sorry that we didn't have any questions, but we had a great time up here. So thank you for your attendance. That was great, guys.